I don't have much to say about the tarnishment aspect of the federal dilution statute, but let's go over quickly what it means. So, under the statute, dilution by tarnishment is association arising from the similarity between a mark or trade name and a famous mark that harms the reputation of the famous mark. And so what does that mean? Judge Posner, talking about the pre-amendment version of the dilution statutes, again, imagines Tiffany. Before, we were imagining a restaurant adopting the name of Tiffany and that causing possible blurring with the jewelry company. Posner posits, suppose that a restaurant that adopts the name Tiffany is actually a striptease joint. And he says that consumers aren't going to think that the establishment has the same owner as the jewelry store, but because of the inveterate tendency of the human mind to proceed by association, every time that they think of the word Tiffany, their image of the fancy jewelry store will be tarnished by the association of the word with the strip joint. And so is that convincing to you? It does kind of get at a basic idea about tarnishment causes of action, is that they rarely succeed unless they are about adult services, shall we say, or drugs. And an example of the latter is an early, again, pre-federal dilution statute case from New York in 1972 involving a t-shirt that was marketed with "Enjoy Cocaine" on it. And the court said, to associate such a noxious substance as cocaine with plaintiff's wholesome beverage, as symbolized by its Coca-Cola trademark and format, would clearly have the tendency to impugn that product and injure plaintiff's business reputation, as plaintiff contends. And of course, we maybe know a little bit more about the effect of drinking soda than we did at the time. So, maybe Coca-Cola is not so wholesome, but it kind of gets at this basic idea of when a court may say that an association with a negative product, and then of course raises concerns about what do we call negative, is going to hurt the reputation of the trademark holder. And of course, it's important to keep in mind that criticism of a trademark holder is not something that is tarnishing, right? Saying that a company is bad or evil or what have you, voicing an opinion that they, deserve to be tarnished in the public eye, is not the same thing as creating a trademark association that causes this kind of harm. Okay, and so, you have cases involving things like guns are us or adults are us, and, you have some conflicting precedents there. And so in one case, talking about adults are us for sex toys, a court found a likely association by consumers. But Toys R Us versus Feinberg, where guns were at issue, a court found no likely consumer associations. And, probably the more likely reason for the different outcomes is that a court has a different view about guns than it does about adult products, insofar as what may be deemed tarnishing. And of course, different parts of the country have different associations with guns, of course, and so that could be shaping outcomes in cases as well. And, as I kind of alluded to before, most successful tarnishment cases are about adult goods or services, or, sex stuff, or, drugs. And one circuit court case that views adult services, adult-themed products as being tarnishing is V Secret Catalog. And so there, the tarnishment claim is based on the idea by Victoria's Secret that they are going to be tarnished by association with the defendant's adult store, Victor's Little Secret. And it's hardly the case that the plaintiff shies away from association with adult themes. But they say, some things are just too adult, or just not what we have in mind in terms of, what's wholesome about Victoria's Secret. So anyway, what's the evidence of likely tarnishment here? And what they have is an affidavit from a customer expressing offense. And so, query what exactly does that prove? Because it turns out he was offended on behalf of the plaintiff. He felt bad for them because he knew that it wasn't them, and it had resulted in no particular changes on his part towards his feelings towards the plaintiff's product. So query whether that actually shows what it purports to show. And it gets back to this idea we've been talking about now, that it's, we don't necessarily have a clean sense of how we prove a likelihood of dilution, be it by tarnishment or by blurring, because we don't have the cleanest mental model about what exactly is going on in a dilution setting. Nonetheless, the court upholds summary judgment. And here again, we see shortcuts and says that there's an inference that use of a mark to sell sex-related products likely tarnishes a famous mark if a semantic association is present. And, that's odd when you think about it, because you're just assuming that if certain facts are in place, the plaintiff wins. And the court actually acknowledges, we agree that the tarnishing effect is somewhat speculative, but who has the burden of proof? The burden of proof is on the plaintiff. And the court says, yeah, but we have this sense that this is what Congress wants us to do. The restatement, is kind of consistent with this view about how to view adult things, and the defendant hasn't rebutted anything. And it's worth noting that this is sort of the continuation of the case that led Congress to amend the dilution statute in the first place, because it was this litigation that led to the Supreme Court holding that under the old statute, actual dilution was required. Congress didn't like that, and so they amended the statute to say likelihood of dilution is good enough. And so the court says, Congress kind of wants us to do that. And the dissent by Judge Karen Nelson Moore isn't having it. And I think it's a quite correct dissent, right? It's saying, look, what the majority is doing here is shifting the burden of proof. And what the plaintiff needs to do in any civil litigation is come forward with evidence that meets its burden of proof. And in this case, even though likelihood of dilution is an easier standard to meet than actual dilution, it's still the plaintiff's burden to meet its standard. And we don't have any actual probative evidence that there is a likelihood of dilution by tarnishment. And as we referred to before, the objecting viewer knew that the plaintiff wasn't responsible for the goods. And there shouldn't be any kind of special rule for sex-related product services. Again, this idea that Victoria's Secret isn't exactly the most wholesome product in the world if you take that view of the world, that there's something wrong with adult-themed services. And if that's the problem, then it's not as if the plaintiff is coming to the court with clean hands. But nonetheless, the court upholds summary judgment in the plaintiff's favor. In point of actual operation in these cases, usually if you see a successful tarnishment claim, again, it's about sex or it's about drugs. And so likewise, in the Chewy Vuitton case that we talked about in an earlier lecture, there was an attempt to bring a tarnishment claim saying that, somehow this was going to hurt the reputation of Louis Vuitton if there's Chewy Vuitton dog toys out there. And the court just, isn't having it. There's no proof of any harm to the reputation. And, the fact that the products sell at different price points doesn't, have any bearing on whether or not there's going to be tarnishment. And there, some assertions by the plaintiff that there may be some adverse associations, or like, what if a dog chokes on the toy? And the court, just says, that's all speculative. There's no actual evidence here. So, again, below that's kind of in keeping with the idea of this, what kinds of cases have successful tarnishment claims brought in favor of the plaintiff. And so we'll leave it there. Thanks very much.